So, I know you've had some work on your bill, which is the zoning provisions dealing with what is notice requirements, and we're pleased to have you here.
Well, thank you, sir, and I'm glad to be able to come. The bill has been worked on extensively since last year, and we come back with a proposal to you. It will be legislative 29, the LC 295127S is the substitute that came out of the subcommittee, and the changes that are noted there for protection of our property owners by requiring additional information on zoning notices is one that we wanted to also include the date, which is on line 17, on lines 24 and or 25 through on the second page, following through to 32. What we're additionally asking is that when notices be sent out, in addition to the one post and sign that is on the property to be rezoned, but the notices will also be sent to the adjoining property owners of that piece of property through the U.S. mail. Also, we have put in on the third page to note when proposed zoning is around a halfway house, drug rehabilitation center, or other facilities for treatment of drug dependency, that also any zoning that is changed there, we would request that notification be put out to the other adjoining property owners by mail.
Good. Any questions of members of the committee of Ms. Purcell? I'll add up as a follow-up that we've had discussions about this, and one of the things that we were concerned about, there's actually two areas of notice provisions we have in the law addressing zoning, and that is the one is of general legislation, meaning when local governments enact an ordinance itself or modify the general law of ordinances. There are certain things to be done as far as publishing notice, but I felt going beyond that, where you'd have what may be anticipated a need to give individual notices or posting on property notices. That to me was fraught with danger because of the fact that you could have a property not posted, then you're open to all potential claims of litigation and invalidity of the ordinance. I do agree with the ordinance when you have a specific property being rezoned, change the classification of a single property or adjoining properties, whatever. What you do in here is really what most governments, I understand, do now anyway. That is, they do post signs. They do, in most cases, give the adjoining property owners notice. But I think it was appropriate to do something to be sure that we cover everyone that has zoning needs, that we provide for those requirements. So I think we've come to that point with a good bill. Anyone else have a comment or wish to make question? Okay, we need to see if anybody else in the audience wish to address the committee on the bill. If not, we will close off further public input, and the bill is now in the breast of the committee, and the chair will entertain a motion.
Mr. Chairman, may I make a motion do pass?
Yes, sir. Do pass. Motion is do pass. There's a second. Any discussion on the motion? And we have, I believe, Mr. Weldon, you wave. Mr. Jacobs.
I may need Ms. Travis for this. I see she stepped out there. Can you maybe?
Step out for a smoke.
We had passed some language, a little additional language there on lines 101 and 102 out of subcommittee. Not sure I like the way this reads, because you've got a plural there and then you've got a singular. Addressed to the adjoining, would it make sense to make it addressed to each adjoining property owner as reflected in the tax records of the county in which each adjoining property is located?
Yeah, the problem was that in the earlier ones we're talking about the way that the phrasing was each owner, looking at line 28, each owner of property adjoining the property.
Yeah.
And then that language got changed, and I'd asked Catherine, certainly there could be more than one adjoining
Could
owner,
well be, yeah.
So maybe we need to try to replicate the language that's earlier in the bill with respect to that?
I like the language earlier, but I'm glad you caught that. Let's make that change. We could address to each adjoining on line 100. Is that what you're saying?
Well, it's each, the language that's earlier in the bill is each owner of property adjoining the property subject to it. That's a little clunky. I would just go with address to each adjoining property owner as reflected in the tax records of the county in which such adjoining property is located.
All right.
Can you repeat that for me one more time?
Strike the on line 100 and replace it with each. Make owners singular on 101, and then change the to such on 101. So it would be addressed to each adjoining property owner as reflected in the tax records of the county in which such adjoining property is located.
All right. You want to make that in the form of a motion for
So
amendment?
moved.
We have a motion for amendment. It's been seconded. We'll take the amendment first. All in favor of the Jacobs amendment signify by saying aye.
Aye.
Opposed, like sign. Do we have any other amendments to? Motion for amendments. Mr. Weldon.
Mr. Chairman, I think that Ms. Travis was referring to somewhere on line 28, and I was trying to make sure I followed that, and I just want to make sure we get this. I'd just like to make sure I'm straight with the modification.
I think what you was concerned about is there's a little different type of expected, I won't try and find the word,
Okay.
use of properties, and there's a little bit, therefore, change in the way the wording is between
Okay.
Section 3 and the Section G that we have, 3 being a part of Section B, which deals with individual properties.
Okay.
I think we're fine.
I think it'll work.
All right. Anyone else have a motion or further discussion? Not, the chair will call the main question. All in favor of House Bill 268 as amended as a committee substitute, signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you,
Mr.
Ms.
Chairman and
Purcell.
Committee.
Next we'll have is Representative Lindsay, not present. We will hold that one. Representative Brockway. There you are. This will be House Bill 748. Good afternoon,
Mr. Chairman.
sir.
Good afternoon. Thank you. Ladies and gentlemen of the committee, thank you for your time. I bring before you House Bill number 748. What House Bill 748 seeks to do very simply is to allow adult adoptees to obtain a copy of their original birth certificate. Under present Georgia law, they have to obtain a court order to do that. There's a number of reasons that we think this is necessary. Birth certificates are needed in a lot of areas of life, and original birth certificates especially. For example, maybe your health records. Doctors more and more are wanting to see family history, and so adult adoptees need to be able to have access to that information. And really, I believe more fundamentally, people just really have a fundamental right to know, their history, a right to know where they came from, and that's really the main reason I think we need to bring this bill. There are 7 other states over the last 10 years that have introduced laws such as this. A lot of the some of the concerns that people have about releasing this information those problems really haven't developed in these other states. Those states include Alabama and Tennessee, by the way. So I would ask for your favorable consideration of this bill, and we've got Mr. Jim Outman is here with us, who's helped write this bill and can help answer any questions that the committee may have.
Thank you, sir. Any questions of the committee for the presenter of the bill? none, is there others in the audience who would like to speak to House Bill 748? Looking at you, Mr. Allen, you want?
Only if the committee wanted to hear you. Just ask for the order.
Wise young years. We have no one else that would.
Mr. Chairman, I got a question about this.
All right.
It's not that I'm necessarily opposed to it, but it's a question that has come up. And that is, if you have siblings, one is over 18, you got one that's 15, 10, 8. What's to keep the 18-year-old from sharing this information with the 8-year-old?
Your Honor, are you assuming they have the same mother?
Well, that's it. I mean, if they have, well, that's a good question.
See, they wouldn't know until the 8-year-old got their birth certificate and they said, "Hey, we
Well,
did."
But it's,
So, Your Honor, I would defer that he won't know that until the younger one gets access to theirs.
but if all four of them are adopted as a family, follow me?
Yeah, I do. But
Are you creating a problem is what I'm asking.
I would say not, in that if they're adopted today as a family, they probably know who they are anyway because adoption is more open. But we go back to the fundamental right of the adult adoptee. It's their birth certificate.
I understand that.
It's not the mother's birthing certificate. And it belongs to that individual.
That-
And while that individual has the right to it under this bill, they don't have to go get it. And if the 18-year-old wanted it, maybe the 18-year-old has the maturity not to share it with their younger sibling because it wouldn't make any difference to the younger sibling. So
Yeah.
I think it's a, yes, how many angels could dance on the head of a pin, but I don't think it's
Judge, how would anybody know if you were 18, let's say you're 22, and you've been adopted, there may be other siblings that you never knew about or aware of. Maybe you were put up adoption by a mother who's unwed, and then later she does get married and has other children. I don't know how under the law we'd be aware of the fact, or somebody would be aware of the fact that there is out there maybe other siblings that would have.
Mr. Chairman, I understand everybody's concern.
Yeah.
I'm talking about if there are four siblings that are truly siblings
Mm-hmm.
of causing problems for a minor.
I understand. We have some questions, I believe, of the committee members. Are these questions to be to the presenter, or you want to discuss it, or what?
Mr. Chairman,
I'll recognize Mr. Weldon.
Mr. Chairman, if I could address this to the judge, please.
Yes.
Your Honor, I guess I'm just having a hard time seeing exactly. I don't practice this type of law, and I'm not familiar with it as I'd like to be. Have you seen a situation where it caused problems within the family, or is an issue there?
Where I see it causing problems in the, I've had several, and Representative Maddox knows of one that he represented
Okay.
an adopting stepmother, wasn't that right? That's correct. Without getting into too many details, where we have, let's see, that was out-of-state great-grandparents also having visitation rights with minor children that caused all kind of problems. And if there had been an 18-year-old in this one, then we got the uniform, what is it, uniform, I can't even tell the name of the act.
Custody?
It was a custody matter that became a part of a contested adoption of minor children. And if you had it would have really interfered if you had a
Uniform Child Custody Jurisdiction Act.
Right, but
If there
if
was
you
a
had
previous jurisdictional custody award in the other state, that state had primary jurisdiction
right.
and continuing jurisdiction.
And this became a part of an adoption issue here, and if you'd have had an 18-year-old we would have had, and you had already done this, then it, on another child, then it would have become if the 18-year-old had gotten we had gotten a copy of that birth certificate, then it could have interfered with what we were doing, or what they were doing in South Carolina. Isn't that right, Billy? This one became complex. Let me put it that way.
Yeah.
I mean, I think if
And that's the only
I would
concern.
say, Your Honor, that if the grandparents came into this action and their last name was the name of the birth mother, the cat's already out of the bag.
I know we're going to have a
If they
problem.
identify that they're the
I'm gonna have to get-
grandparents of the child from the maternal
I'm gonna have to
side,
ask you all to
they've
come
already
up front.
identified that unknown.
Mr. Albany, we need to get to a microphone so that people who may be listening to us outside the committee room can hear the discussion.
I apologize.
Mr.
Yeah.
Chairman, I'm not trying to interfere with your bill. It's just I'm only asking in the event that it is if it's used for an alternate purpose by the adult child that would interfere in any way with a minor child.
Okay.
And that's my only concern. If it's a true sibling, I mean same mother, same father sibling, and that have been adopted, and there may be a problem there with sharing information.
Well, thank you, Your Honor. And
Yeah.
if
Go ahead, Mr.
I
Brockworth.
just obviously these sorts of matters are very
Rare.
well, and I respect the the delicate nature of these sorts of things, and we certainly understand that and want to make sure we take all of those things into account. But I would think that they were rare, and I would think that I would hope that the people who are the adult adoptees who are seeking this information are seeking it for a particular purpose, not to and having experienced that situation themselves of being adopted, understand the delicate nature of the information they have, and the information spreads in all sorts of ways.
Yeah.
That may or may not that we just can't control.
Ms. Evans, do you have a question or comment?
Yes, thank you, Mr. Chairman. Two questions, really. The first question, focusing on lines 52 to 54, that last sentence where it says the copy of the original birth certificate shall be in a form that clearly indicates it's not certified and it can't be used for legal purposes. I'm just wondering if there's protection in place somewhere else in the code, and I'm thinking of the bill that we passed last session that had to do with folks who needed to find out their original birth parents for medical purposes, because I wouldn't want to tie someone's hands. They might need it for legal purposes. So do we have other ways that we are protecting the ability of adoptees to be able to use the information about their original birth parents for legal purposes if they need it?
I'm not quite following your question. I'm sorry. Could you restate that?
Maybe I don't understand my own question, but I can envision a situation where you might need to know your original birth parents' information for legal purposes. And so do we have, and I'm not coming up with a scenario, but I suspect there might be, and so do we have protection somewhere else in the code so that we're not tying the hands of these adoptees to never be able to use this information that they know to be true about their birth parents for legal purposes?
If I might start an answer to that, and then we'll let Mr. Altman, but the reason that is worded the way it is because there is a new birth certificate having been issued to that child from being adopted, and that is what we will call the official birth certificate of the child. It is not what we call an original birth certificate, but an adopted birth certificate. What we're concerned about is being sure that this document that is given to the person upon this ability to obtain a copy cannot be then used outside needs or sources as a, quote, qualified birth certificate. What did you say, Mr. Altman?
You did the term, the Vital Records Act says you amend the original birth certificate, and therefore the amended certificate becomes the official one. The theory is they can't certify both of them as the same birth certificate because a child then has two different names, may have two different places of birth. Usually they should have the same date of birth, but we have found occasions where that's been tampered with too. But the the key is the legal purpose is the last card played, the last name. If they went to the court and got a Superior Court name change order, that would be the last name they can have. It would differ from the birth certificate.
Mm-hmm.
So you would have to have all those things to trace the history back. Where we have individuals in a need for this document is getting a passport, because if there's been a change in anything in the place of birth or date of birth, which has occurred, then since 9/11, the State Department shuts down if there's any question, and you can't get a passport until you can get your OBC. Here is a copy of an OBC that I obtained under court order, and it says canceled by adoption up here. Now this, I've whited out the name so I can pass this around if you wanted to see it. The point is, this is the type of document we're presenting that someone needs to see who's adopted, and that's me. That's the one piece of my puzzle that I can't find without this bill, without going to a court and paying a lawyer. And so some people have said, "Hey Jim, you're getting rid of your work." Yeah, but I think it's the right thing to do.
And so when we're referring to legal purposes in here, we're talking about, I guess, inheritance, names, identity, things like that. But you don't think that it would interfere with anybody's ability to use their birth parent information for medical purposes or anything like that?
No, and I don't see the legal, I don't see that as an impediment to establishing that you were born. The decree of adoption terminated your inheritance rights from that birth parent by a matter of law.
Yeah, and I'm not concerned about inheritance. I was just
we're not
asking.
backing into an inheritance. I've had to open this for a gentleman whose daughters wanted to apply to be daughters of the American Confederacy, and the birth mother was a member, but by the adoption they couldn't prove the link. The birth mother supported the petition to the court. I went to a judge, not this judge, I'm deferring to the judge, and they granted the petition. Well, that allowed them to complete their application for Daughters of the Confederacy. Is that a legal purpose? I'm not sure, but I think the legal purpose here is to say, this is your birth certificate. No, the amended one is your birth certificate.
Okay.
That would be my response.
Thank you. And one further question, Mr. Chairman, if I might.
Yes, ma'am.
Thank you. In section, right below that, subsection 2, starting at line 55, I understand that the purpose of the bill, and I think it's a good one, and people do deserve to know where they come from, and I don't have any problem with that. I'm wondering, though, with that being the overriding purpose, what is the purpose of this section where we're allowing someone to find out the information after the adoptee is deceased?
Well, if the children of the adoptee are trying to do their family tree and their dad died, but he was the adopted link, they're dead in the water without that sentence. And we picked that up, by the way, from another state that had done this, and we saw that and thought, that's a neat piece to have the link. So if the adult adoptee is deceased, then another limited relative may seek that information. It wouldn't be needed for their passport. They've got their passport already. If that was responsive.
Thank you.
Mr. Welch.
No, you answered my question.
Did you? All right. Over here we have Mr. Powell or Mr. Crawford.
Thank you, Mr. Chairman. And I came in late, and I apologize, and maybe this has already been addressed, but what about the natural parent's desire for anonymity? What does this do for that?
Yeah, and that's a concern, and that I certainly respect that right. I think what they found in the other states that have done this is that really that's a very rare case. And so, I guess it boils down to does the right of the adult adoptee trump the right of privacy of the parent? And I think when you look back at the history of this, these sorts of laws were put in place, and really in order to protect the child and the adoptee back at a time really when there were different attitudes toward adoption than there are today. Adoption really just does not have any more any negative feelings attached to it in these days, I don't think. So I think that was really the intent of these types of laws. So I just feel that these sorts of rights trump the rare case where the mother may want to remain private.
Well, except for the fact that, I mean, we've tried to address in the past what the adopted child's needs are by putting a procedure in place that if he or she wants to trace their lineage, wants to establish contact with other siblings or with their parents,
right,
and there's a procedure, and it may not be the easiest or least complex, but it at least makes an intermediary who then contacts the birth parents and says, your child is now 18 or 20 or 25 and wants to find you. And this just basically says to heck with what they want. You've got the birth certificate's got all the names on it, and they can just pop up on your doorstep one day out of the blue, and that sort of spits in the face of what we've done in the past.
Yeah, and I understand what you're saying, Jay. I just think that the number of reasons, medical reasons, the number of reasons that an adult adoptee would need this information apart from trying to seek the family history, and also would rely on what's happened in other states. As this, over the last 10 years, 7 other states have implemented policies very similar to this, and these concerns were raised at that time, and that certainly is a concern. And not every thing that happens is going to, work out like peaches and cream. But overwhelmingly, the impact in these other states has been very positive. And so I think that, while that is a concern, I think that in the other, you look at the other states as this has happened, it's not turned out to be a real problem. So that would be how I'd answer that, Jay.
Any further? All right. Any other questions from any members? And Judge, you'd like to make a comment? Get up your mic.
I've got a question about on line 48, where it says who was born in the state. How are you going to? Would they have to make an application to find out if they're born in the state? Let me tell you what we're doing. I do a tremendous amount of adoptions in Fayette County. We're doing domestication of foreign birth certificates because of the number of people that are adopting a child that's outside of this country. So you got to domesticate that birth certificate. The other thing that I have been surprised, I have done 3, and these are complicated, in vitro adoptions out of state, 1 out of the country. Now, how are you going to know whether or not that child, is there a procedure?
Let me ask a question first of all, Mr. When you say the birth certificate of that child born in a foreign jurisdiction is domesticated, you mean we take their birth certificate from, let's say, Indiana?
No, it's from Russia.
Well, let's say I'm using states first. Right. Say from Indiana. And do we domesticate that here, or does it stay? We don't need that. So now we've moved a step further. If it's a foreign birth being out of this country, Russia, do we get a copy of their birth certificate? Are we required to get that and have that domesticated as a part of the record here in Georgia?
Yes, sir.
Okay, I got you. But let me ask the question again further. Is it something filed with the vital statistics, or is it just kept as a part of the court record?
I don't know, sir. I'll
Okay.
be honest.
We're amending the Vital Statistics Code.
Let's
here.
pull your mic around, please.
We're amending the Vital Statistics Code here, and in the case of an adoption from Russia that is domesticated under our adoptions code, and that principal reason is to give you a decree of adoption you can read in English, and you could go get another copy if you needed to, because you get one when you leave Russia, and it's in Russian.
That's true.
But you also get a birth certificate from Russia. When you do this domestication that the judge spoke of, you get a certificate of foreign birth issued under a separate code section by Vital Records that says that you were born in St. Petersburg, Russia on this date. So therefore, this code you would read here and say the child was not born in this state. Mr. Chairman, when you spoke of a child born in Indiana, unfortunately, prior to 1993, that child born in Indiana could also get issued a Georgia birth certificate for an adoption that occurred prior to 93 because they issued another one out of Georgia, or they could. Now the procedure is a child comes into the state, born in Indiana, adopted in Georgia in Fayette County. When the judge signs the adoption decree, the attorney files a certificate of adoption with vital records. They mail it to Indiana Vital Records. They issue the amended certificate. This bill would not speak to that because there's no OBC in Georgia for that child. There's only a record that they sent it to Indiana.
The question I have.
Now the in vitro, that would not be an adoption, but the child, if the birth occurred here, there would be a birth certificate. But you're filing a determination of parentage too, probably, and that's going to direct that the hospital issue the birth certificate in the name of the people that your court order did, so that won't show up as an adoption. This bill wouldn't address that either.
Okay. So what you're saying, the issue of this in vitro adoption is something that has to be done. If there's anything to go further in obtaining that record, it's going to require a court order to do it.
Well, the problem with that is there will only be an original birth certificate. That'll be the child's birth certificate. There would be no amendment.
No knowledge of what was the, what we call it, natural mother?
Well, that's the effect of a parentage order is to determine the genetic material of the egg harvested from this woman who is going to be listed as the mother, even though she's not the one giving birth.
Okay.
The parentage order says it's her genetic material, and it may be the sperm from the husband, and it's his genetic material. If they have an anonymous donor on either side, the effect is you say there's an anonymous donor, and the anonymity is in the genetic records, not in the. It's never in the court record anywhere. So getting a court order wouldn't tell you who it is. It's still it's donor number 4573 from Cryogenic Labs.
Mighty confusing. Mighty confusing.
Very confusing.
Is it you, Mr. Who's that had a button down? Ms. Evans, or you, Mr. Lindsay? Excuse me.
I just want to make sure I understand. There's nothing we can do about adoptions that for children born out of state who were brought into Georgia prior to 1993. Is that right?
That's right. And,
okay.
And if they, to
respond
to your question, if they went there saying, I've got a Georgia birth certificate, can I find my OBC? Georgia would say, we don't have an OBC on file. You weren't born here. This was an adoption anomaly.
So it's appropriate that we start this at 18 because for 18-year-olds, because right about now we're going to start having kids who are of age to be able to start using this. 93, 2011.
Oh, well, no, that's good math.
Okay.
It's just a quirk of it was fixed in 93.
Right.
Any further questions of the committee members? If not, is there anyone else who wishes to address the committee? I think we had a couple of names. I can't reach that right now, but if I can slide that over to us, we'll call them up. I've got, I believe, is it Kathy Simpson and Sheila Humberstone? Do I got those names correct? I'll try to butcher the names. Do we have anyone by those names? This is on 850? Yes. I'm sorry, I'm on the wrong bill. My mistake. My mistake. I'm sorry. I lost. Okay, Mary Boyert. Excuse me, come up, Ms. Boyert. Boyert? Thank you. And would you like to have a seat and introduce yourself, please?
Thank you, Mr. Chairman. My name is Mary Boyert, and normally I represent the Archdiocese of Atlanta with its Respect Life ministry. And obviously, Respect Life is very supportive of adoption, and it is certainly a positive solution out of a problem pregnancy. But I'm actually here speaking more on behalf of my own personal experience as an adoptive mother and a mother of a child who placed a child for adoption. And my main concern is what Representative Powell brought out. Both of our children were adopted through the process of a closed adoption, and their birth mothers were given the promise that it was private. and that only if both parties wanted to reach back to see each other at some point in time would that information be made available to them. So speaking more or less from that perspective, I feel that it would be helpful if there could be some sort of addition to the bill, some kind of a process that going forward this information is shared with moms who place their children for adoption, but that there be some way to protect women who are expecting privacy. And that's my big concern, is that this is what they were told, this was the practice, and I understand that it may not be a big problem, but there may be some moms out there or dads who are not expecting to ever have this information become public. So it's not that the diocese or the Catholic Church is specifically taking this as a huge problem, but it does seem that...
You're not speaking for the diocese.
Not really, no.
You're speaking
it's a
individually.
fairness
Let's
issue.
be clear on that point. Okay. And I'll say in response, Ms. Boyer, that has been, over the years I've been in the legislature on this committee as we've handled adoption, a question that comes up from time to time with regards to accessing information from records going beyond the adoptive birth certificate. So we're well aware that is a question that is raised.
Okay, well, thank you very much.
I think the response has been recently, and we'll talk about this bill, if the adoptive child calls up and says, hello, I'm Joe Smith, and I received some records, and I believe you're my adoptive mother, then that person can say, oh, I'm sorry, I don't want to talk to you, and hang up. But that's a choice, or it could be an opportunity to bring them together. Who knows? But that's true.
Thank you.
Thank you for being with us. Anyone else wish to address the committee on the matter? You do? All right. Come up and have a seat, and please give us your name. And
Jennifer Yerfest, and I am a birth mother. In 1969, I was 16 and went through an agency that my parents located for me. And I've been active in the adoptive community from all aspects with adoptive parents and adopted people and birth parents as well. It's my understanding that it's a myth that birth mothers were told that they would have privacy. The privacy was not about us. The privacy was for the adoptive parents and for the child. To my horror, when I found out that when I signed relinquishment papers that I was removing my birth son's civil rights, that I was taking away his rights, and that would be a hardship for him that he would encounter from time to time in his life, and in fact he has. It was not right, and I just don't think that for myself or anyone else, I would ask, who are we to remove another human being's rights, and why would we be, in essence, punishing them? It seems like punitive action to someone who's being adopted, to not have access to their original birthright, to their genetic history, their DNA. I mean, that's our God-given right, in my opinion.
May I follow up with you? It sounds like you and your son that you gave up for adoption have been united.
Yes.
And how did that come about?
I located him when
you did the seeking out, not him.
I did the seeking out because at 16 I really didn't know anything. I didn't understand. I just thought, wow, I'm in trouble. I'm going to, do what my parents want me to do. But in educating myself after 10 years, I realized that if there was any way for him, if he needed anything, if he needed any information, if he had any curiosity, it would be up to me to reach out to him. I felt that it was 100% my responsibility to make myself available to him. Also, I felt that it was my responsibility to not further interrupt or cause any problems with his life. So I waited until he was 19, and I wrote to his adoptive parents and extended myself to them for them to pass on if they saw fit, which they did. And they asked me to wait for him to contact me. I waited another 10 years, and when he was 29, he called me, and he's 42 now.
All right. Thank you, ma'am. Ms. Evans, or is that Mr. Lindsay?
I'll waive, Mr. Chairman.
You waive. All right. Thank you. Any further inquiries of the persons addressing the committee? If not, we thank you for being here, and I'll ask again, if anyone else wishes to address the committee, we're happy to have you. Mr. Altman,
Mr. Chairman,
let me get you. I don't have that mic on. Go ahead now.
I can speak to the issue that was raised by the previous witness that under Georgia law, when the records were sealed, they were never completely sealed. They were always openable by a court order. That same argument that she made was made in Oregon in litigation to block the Oregon law in 2000. The Oregon Court of Appeals said if the statutes did not provide for that promise, then the state agencies were without authority to make any such promise. If the state agents were without authority to make a promise, then the promise that cannot be enforced. And therefore, if anybody promised somebody, and as the last witness said, she wasn't promised that, and we've had other mothers testify in previous hearings that they weren't promised that. The promise was to protect the bastard, if you will. The Oregon court also went on to hold that it was not a fundamental right for a woman to be anonymous to her offspring, that that's not a privacy right one has. So it's been litigated. The point that you raised very well has been up and down in other courts, and I don't think we need to replow that field here.
All right.
Thank you.
Thank you, sir. Anything further from members of the audience? If not, yes, ma'am, you want to step up and have a seat.
My name is Nikki Lebo, and I am a member of the AAC, the American Adoption Congress. I'm also a member of GEAR, Georgians for Equal Access to Records, and I'm also an adopted person, not a child. I am reunited with my birth family. I did not use my birth certificate to get it because I can't have a copy of that. I'm not a Georgia-born adoptee. I'm a New York adoptee, but they have their records sealed at the moment too. And so it's a civil right. It's our civil right to have that birth record. Most adopted persons, when they turn 18, they're not going to go running to people's doorsteps and trying to find their birth family. Is that possible? It could be. But we just want our birth record. It just has information on there that our amended birth certificates don't always have. Sometimes the hospital's missing. The city might be changed. The birth weight might not be on there. And it'd be nice to know that information. Also, Georgia does have a Georgia reunion registry. So if somebody turns, is it 18? No, 21. They can use it to seek birth family. And it's a safe way to reach out to birth family. It's been successful. They advertise it. A lot of people know about it. And I think when Georgia-born adoptees in Georgia, if they get access to their birth certificates, they probably still will use the reunion registry because it's just a safe way to reach out to somebody. And even if you have your original birth certificate, a lot of times the birth father's name's not on there because they have to be married. So the birth mother's name's just on there. It's usually the maiden name, and so their name could have been changed, which would also make it harder for them to find if you just take that name on the birth certificate. So I just ask you to please vote in favor, and that's all.
Very well. Thank you for addressing the committee. Does anyone else wish to speak? Yes, ma'am.
Thank you. My name is Denise Carroll, and I'm also a member of AAC and GEAR. But more importantly, I'm a Georgia-born adoptee and an adoptive mom. I've been in reunion with my birth family for many years, but this piece of paper is still part of my history and my truth, and I really want it. It's a piece of me. I mean, I have met my birth family. I have a wonderful adoptive family. It's, like Representative Brockway said, it's a piece of the puzzle that unless you're adopted, I don't think people understand. My birth father was adopted, and he's now deceased. But his wife told me he was able to get his somehow. And the day he found it, I think his adoptive mom must have had a copy of it. He wept because he saw what his original name was. There was just something very primal there that you connect with. It's where you begin. And it's just very important for many adoptees to have that piece of paper.
Thank you, ma'am.
Thank you.
Appreciate you talking to the committee, addressing the committee. If there anyone else wishes to address the committee, if not, we will close off further public input. The bill is now on the breast of the committee, and the chair will entertain a motion
Do pass, Mr. Chairman.
on House Bill 748. We have a do pass motion by Mr. Jacobs. Is there a second to it?
Yes, sir.
Been seconded. Any discussion on the motion, first of all, among the committee? If there's not any further discussion, do we have any amendments? If there are no amendments to be proposed, the chair will call upon the original question, which is a do-pass motion to House Bill 748 as presented to committee. This was not a committee substitute. This was straight. And that is LC 334395. All in favor signify by saying aye.
Aye.
Opposed, like sign. Aye. I believe the motion carries. This is a call for hands. The chair rules the motion passes. We will have next the House Bill 744, Mr. Lindsay's bill. Oh, yeah, I'll look at it.
Thank you, Mr. Chairman. I'm here to present House Bill 744, which is the Uniform Partition of Heirs Property Act. I'd first like to thank the subcommittee chairman, Representative Jacobs, for not only passing my bill out, but also for not changing the name.
Was there?
Yes. Yeah, turnaround may be fair play here. In all seriousness, you have, hopefully each of you have two sheets, the two documents in front of you, from the Uniform Law Commission, sort of explaining a little bit about the Partition of Heirs Property Act, a summary. As many of you already know, I have the great honor of having served on the Uniform Law Commission as one of the Georgia's three commissioners for the last 3 or 4 years. And this is one of the bills that has come out of this commission and is being recommended to the states for passage. What the bill does, quite frankly, is makes it easier for heirs property, and heirs property is defined under the Act, to be partitioned and to come up with a more equitable way of doing it. This property is the kind of property that passes from generation to generation without a will. Sometimes it passes through multiple generations without a will. We generally find this sort of situation oftentimes in two very interesting and different settings, very rural and very urban settings, and usually, quite frankly, among folks of lesser means. What often happens is that someone will come in and buy one small portion of the rights to a piece of property, and then force a partition, and underneath the present law, be able to force it to go to a sale on the courthouse steps, and the property is then usually bought by the person who has a small interest at a much lower value than market value. And what the Uniform Law Commission has attempted to do through this bill is come up with a more equitable way of dealing with heirs property, and also to recognize oftentimes its historical and family significance, and to come up with a more equitable way to come up with a fair market value. Section, if I can just sort of briefly take you through it, Mr. Chairman.
Yes, sir.
I'll be happy to do whatever detail folks want, but sort of 44.6.180, basically the definitions. Probably the most interesting part of that is found on line 32, which deals with the definition of heirs property. 44.6.181 simply makes it clear that if the court determines that the property at issue that someone seeks to have partitioned, the court will make a determination as to whether or not it's heirs property. If the court does make that recommendation, then the property will be partitioned underneath this act as opposed to other provisions for partition under Georgia law, unless the parties agree to do the other method. That's always an option. I'm sort of hitting the more detailed parts of the bill. 44.6.184 deals with, I want to make sure I didn't jump
And Miss Bruce, when you're a chair, we'll let you go way out there and have dinners. All right. We have one last bill. Please, Miss Lottie. One last bill. House Bill 850, which tried to get people to talk on earlier. Where's our presenter? Mr. Harold, come on. Sit down and get comfortable and tell us about House Bill 850.
Thank you, Mr. Chairman. This is my first appearance before this most prestigious of all committees.
You're right. Your first appearance, I mean.
I'm available for dinner, too. House Bill 850 in your folder was passed out of the Chairman Lane subcommittee, and it deals with probate court and probate judges' ability to permissive ability to request a background check that would include fingerprint and FBI information in relation to assigning guardianship or conservatorship through the probate court.
Mm-hmm.
There is also a proposed substitute in your packet that includes additional language with regard to physicians' orders for life-sustaining treatment that falls under the same title, code section, or title. And what I understand is that this provides
Jill, you want this book?
Liability language for physicians in carrying out these orders. Now, I've discussed the...
When you say these orders, what are we talking about, orders?
The physician's order for life-sustaining treatment.
Okay.
Yes, sir. That appears in the proposed substitute appears on the lines 12 through 14. I discussed this proposed modification with Chairman Lane. Again, the substitute did not appear before his subcommittee, but I discussed it with Chairman Lane. He is agreeable. I discussed it with each of the authors of the original bill, Chairman Willard, Representative Oliver, and Representative Holcomb, as well as the Trial Lawyers Association reviewed the legislation and proposed wording, as did the medical community that brought the proposed substitute. To the best of my knowledge, both with regard to the original Bill 850 as well as the substitute, the various interested parties are all in agreement. I am aware that counsel for the committee may have a comment or recommendation to make with regard to the substitute.
All right. Anyone have any questions of the presenter regarding House Bill 850? We do have over there Mr. Powell.
Is there a particular problem that we are attempting to address here, something that has happened that has presented some kind of issue, and that is why we're here?
Yes, sir, and in fact, Judge Jordan is here. So
Would you like to step up, Judge Jordan, and have a seat, and we'll pull your mic around there and let you respond to Representative Powell.
Representative Powell, it has arisen from several different situations. The probate judges and guardianships and conservatorship matters already run background checks pursuant to a court ruling, the Uniform Probate Court rules that was adopted by the Supreme Court. But that is limited to just Georgia GCIC records. We need to have a statute, and this has been submitted to the FBI for approval by the GCIC, who's approved it here in Georgia, to be able to get federal reports like we do when we issue firearm permits. The specific instance or instances which has caused us to work on this for a couple of years now, it started back when I was president of the council, is like in Henry County, where we are having now a lot of mobile folks basically running from jurisdiction to jurisdiction and not re-registering as sex offenders, and they will present applications for guardianships over little children, and just by chance we may happen to find one once in a while, And it's that situation, it's the Mickey Rooney type situation for incapacitated adults, where something may have occurred in another state that we're trying to take care of. We already get the background checks, but we need some national input too, like we get on firearms, so that's what changed here.
Follow up, Mr. Chairman?
Yes, sir.
I guess there's two parts to my follow-up. Number one, how much additional time does this add to the appointment process of a conservator or a guardian? And then my second part is, could you not accomplish the same thing by doing an NCIC check rather than having to submit to the FBI, et cetera, et cetera?
Well, this is NCI check. This is getting the data back from the National Crime Information.
Okay.
And it will not add any time. If you're talking about the adult incapacitated adult situation, you've got built-in delays already. On a temporary guardianship, it won't cause any more time because with the new electronic fingerprinting procedures that we have, we'll have it back in 2 days at the most.
Okay. Thank you, Mr. Chairman.
Yes. Any other questions of the presenter or Judge Jordan, since you're sitting there? If not, that's fine. Thank you so much. I think we did have one other person or two other individuals. Sheila Humberstone, thank you. I was not sure if that was a B. And Kathy Simpson. If y'all want to come up here, and I'll ask the two other. All right. Well, you be the only one, or is both of you? Both of them coming apart. Please do. Pull the mic around where y'all can share it. There you go. That over there. We get you another mic right there if you want to use that one. And introduce yourself to the committee. It helps to have the mics on.
Good afternoon, Mr. Chairman, members of the committee. Thanks so much for letting us be here today. I'm Sheila Humberstone, work for Troutman Sanders, and I'm here on behalf of the Alzheimer's Association Georgia chapter. And this is Kathy Simpson with the Alzheimer's Association. We worked as background a number of years ago with Representative Lindsay and others on a bill to enable another tool in the toolbox of end-of-life decision making. It's a reduces basically an advance directive into a simplified form that can be acted upon by a physician. It turns an advance directive into a physician order. This language worked in tandem with an adult guardianship bill that was also moving at the same time. At that period of time, we opted to provide some authority to the Department of Community Health, which is now housed at Public Health, for them to create this statewide physician order for life-sustaining treatment form. We're back today because we think that the state will be issuing a form of that kind at some point in the next few months, and most likely before the next legislative session. And we have real concerns about the physician and hospital liability piece. So what we've done here is to try to attach the same immunity from liability that we have in the Advanced Directive Code and for DNRs to these pulsed forms. My biggest fear is that a family pulls this form off of DPH's website. They have that sometimes painful talk about what that end-of-life care treatment plan will be. And they fill it out. They show up at an emergency room. They hand the form to the physician or the hospital administrator, and because there's not the liability in place, they don't accept that. And then the family's having to revisit all of these decisions all over again. And so we're hopeful, and we've worked with not only the Alzheimer's Association, the Georgia Hospital Association, the Medical Association, the Nursing Home Association, the EMS Association, the Academy of Family Practice Doctors, which is the Family Practice Docs, and the American College of Physicians, which is your internists, to come up with some language to try to protect the medical community. We've also worked with the Georgia Trial Lawyers Attorney Association, and they're supportive of this effort to sort of use some wraparound immunity language.
Okay, let me explain for the other members of the committee what we're addressing is there's two bills, I think, in your file. If you look, there is a bill that is identified as LC 295077, and then you have another of the same 850, which is LC 211604. The difference is, you will note there's a additional Section 1, which dropped the Section 1 of 77 down, And what you're addressing is placing in there a limiting of liability and immunity granted for those who act in good faith on these medical electives that are brought in with someone who is not able to speak for themselves, right? And the question you wanting to ask this committee is to have that added as a provision to this. They come out of the same title, although different chapters and therefore different subject matters.
Exactly.
Okay, so I want to
And
have the
similarly,
committee.
that's how we came out originally a couple years ago.
It's what now?
That's how we came out. We ultimately passed a couple years ago. It was an adult guardianship bill. They've added our provisions in there as well.
Right. So that is the issue. I just want to be have everyone on the committee be aware that's what we're talking about, which you raise this point.
And if you have specific questions about the document, Kathy's
Sure.
really well versed in it.
Do we have any questions of Ms. Humberstone or Ms. Simpson? Ms. Simpson, I didn't mean to cut you off. You want to say anything to the committee?
No, sir. In honor of your time, I would not.
No
unless
problem.
there is a question.
We're here till dinner time. Okay. That way I thought maybe you might want to go with us, Mr. Bruce. You can come with us?
He said that.
Okay.
As long as you're here.
Okay. No questions, then we'll thank you both
Thank
for
you.
being with us. Do we have anyone else who would like to address the committee on House Bill 850? If not, we will close off further public input, and the bill is now in the breast of the committee, and I will ask for any committee discussion. And we have Mr. Powell, you want to address the committee?
I would like to ask the author and the judge one final question. if I
All
may.
right. If you'd like to have Judge Jordan come up again, please, sir.
Yes, sir, and I think it's clear, but I just want to be
Sure.
reassured on this. This is not the underlying bill that you've authored. It's not mandatory, it's discretionary.
It's discretionary, and that's the way it's written now in the court rule.
Okay, thank you, sir.
Very good. Any other discussion among the committee? And I have Mr. Weldon.
Thank you, Mr. Chairman. In this, on line 12, and this is for the committee or Mr. Chairman.
This is on Bill 1604S, right?
Yes, sir.
Okay.
On line 12, it says any person who acts in good faith in accordance with a physician order for life-sustaining treatment. Is physician order defined in OCGA 29418? Okay. So that's why we're not saying
Well, we
a
got
physician.
two different answers here, and we'll hold them. First of all, ask Ms. Travis to look in if there's an area of definitions. Physician orders is not, and I think
It's not defined in 29.418.
is
Okay.
it under that chapter.
Physician's order for life-sustaining treatment, to the best of my knowledge, is in Title 31. That's the cross-reference.
It's not in Title 31. It's in that adult guardianship code section.
It's not in 29.418. It might be in a different.
Is it in 31? Okay.
If there's a
What, the,
I'm in, oh, you're in the
that
The language says something along the lines of the Department of Community Health, now it says Department of Public Health shall create a physician order for life-sustaining treatment, comma, a specific form signed or acknowledged by the physician, the patient.
Let me ask you this, Ms. Humberstone, if you would please, you go to that mic on the very corner there, use that if you would.
Sure. Can you hear me?
I think we can hear you now. So
I think the language is in the Adult Guardianship Act. It's at the very end, and I could probably pull it for you if I could see the book. But it basically says that a physician order for that the Department of Community Health is how it was drafted, but now it says Public Health because of the changing of the state agencies. The Department of
well, the
Public
question
Health
we got is this:
shall
is there? Understand? The question is, in looking at this particular code section, do we have a means of saying there is a connection between that code section back to where you have your definitions?
Well, it's defined a little differently. I'm not a lawyer, so you have to forgive my naivety here. But it says that a physician order for life-sustaining treatment is a specific form created and published by the Department of Public Health. and that it's signed by the patient and his or her representative with the physician.
All right. So, Mr. Lindsay.
Just take a short break.
I think we need to be.
But then we could refer specifically to the code section, so when folks in
Right.
position order, they'll know what.
As defined in.
Yeah.
Right.
Let's do that maybe for a second. If you can let Ms. Travis give us some guidance on that point, since we trust her draftsmanship. Yeah, I think you're right. Hey, Donna. Hold on a second. We'll take a couple minutes recess while
which I was very happy to see.
that's worked on.
Give her a mic.
All right.
Here we're back in session.
Okay, so one of the problems is that the L looks like a 1. And so it already says what we have it to say, develop pursuant to subsection L of this code section. So the reference is there. My only other suggestion for you all, if you want to tie this in and make this more subject matter related than it presently is with the 2 sentences, is if we adjust the title to deal with guardians generally. And then we say we're going to deal with guardians generally. We're going to deal with them in the manner of dealing with these.
So you're looking at the enacting clause at the top.
The title of the bill on lines 1 through 5.
1 through 5, right.
Right. Now we just need to, yes, we need to just adjust that a little bit more, and then we'll.
Well, it says relating to guardian and ward.
That's the name of the title.
Yeah.
And the very first one is so as to provide an exemption. And then the other one is to provide a criminal background check. If we added a clause in there, so as to provide for guardians generally, or to provide for guardians, matters dealing with guardians generally, or something like that.
Where would you put that?
After the so as.
You want to strike the rest of it by exemption for liability, or just say that is additional?
Yeah, additional.
Okay, so
it's
line 2, so as to provide for guardian.
For matters relevant to guardians generally. And then.
Okay, and then go on to and an exemption.
To provide for an exemption.
And to provide for it.
No and.
Oh, I'm sorry. Okay.
That will help deal with your subject matter issue, as opposed to having 2 different distinct issues. And then the question that Representative Weldon was raising with respect to we need a definition. I think it says develop pursuant to subsection L of this code section, and subsection L is where the form is talked about being developed.
All right.
We just have to be able to read. You
Yes.
especially.
Well, we're always grateful for your input. Thank you, Ms. Travis. I think we're at that point where we can move forward with the further discussion. We have no one else who wishes to address the committee from the audience on House Bill 850. If not, the chair will close off further public input. The bill is now in the breast of the committee, and the chair will entertain a motion. We have a motion to pass, and I hear a second. Do we have any discussion on the motion? First of all, if there's no discussion of the motion, the chair will entertain any amendments, if any, to the motion. And let me read what I've got here. I'm going to read what I wrote down on line 2, starting with line 2, so as to provide for matters relating to guardianship generally, comma, or semicolon, to provide for an exemption from liability for persons who comply with a physician order for life-sustaining treatment, semicolon, and reading on.
Yeah, so moved.
That is the chair's motion. There's a second. All in favor of the chair's motion signify by saying aye.
Aye.
All opposed, like sign. Do we have any other amendments? If not, we'll go back to the main question, which is a due pass of House Bill 850 as a committee substitute now. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. We have a favorable motion on the bill. Thank you very much. Glad to have you with us today, Mr. Harrell. Thank you, sir. There be any further business to come before the committee. If not, the committee stands adjourned for the day.